Good morning, Mr. Margolin.
Good morning. Please, the Court. I was going to move on then to touch on, I hope quite likely, three more recent cases where the higher courts have declined to adopt a conforming construction. Fleming, which I hope I'll deal with very briefly, FII Supreme Court 1, and Routier. Fleming, as we have seen, concerned the new shorter time limits for VAT claims introduced without a transitional period, and raised an issue akin to that which arises here in the context of conforming construction, and also in the context of disapplication, which is a matter raised in HMRC's Respondent's notice and addressed in our supplemental skeleton, which is to say, how far was it proper for the court to specify a period after which the new time limit began to apply? We say that the decision in Fleming is helpful in showing where the dividing lines to be drawn. I know Mr. Johnson's already taken you to Fleming in some detail, so I'll confine myself to dealing with a couple of aspects briefly of their Lordship's decision. Our written submissions on Fleming are in paragraphs 21 to 27 of our replacement skeleton at pages 2, 3, 3 of the core bundle. Now, as I say, it's relevant in part to the question of disapplication or partial disapplication, because the revenue contends that if a conforming construction isn't possible, then the relevant legislation, which they say is and is only Section 59D of the Taxes Management Act, should be disapplied to the extent necessary to secure compliance with EU law. Given its approach to the issue of conforming construction, the FTT didn't consider it necessary to deal with disapplication, and for the same reason, nor did the Upper Tribunal, but it's now raised again by the Commissioners as an alternative basis on which to uphold the final closure notice. Properly analysed, we say it must be HMRC's position that if a court or tribunal, and if indeed this court, has held that it's not possible to rescue legislation by way of a conforming interpretation, whether that's because it would go against the grain of the legislation or would raise policy issues which aren't apt for determination by the court or would amount to impermissible judicial legislation, nonetheless exactly the same outcome can be achieved by way of a limited or partial disapplication of the relevant provision or provisions. And we say that, on the face of it, that's a very surprising proposition, which calls for a rather more detailed explanation by the Commissioners than it's benefited from so far. In our submission, if ex hypothesi a conforming interpretation isn't possible for one or more of those reasons, then a partial disapplication, whether it's of Section 59D or of the charging provisions, to produce the same result, must be equally permissible. And indeed, creating some sort of time-limited partial disapplication to create a deferral period must essentially face the same objections as a conforming interpretation, which involves writing in a deferral period in terms of going beyond the proper role of the courts and contravening the principle of legal certainty. Now, the Commissioners in their skeleton at paragraph 57, so that's page 268 of the core bundle, say that our reliance on Fleming is misplaced, primarily because that case was not concerned with conforming construction, but rather was concerned with the doctrine of disapplication. We say that it's not irrelevant for that purpose, but it may, on that specific point, be helpful to note the difference in approach as between this court and the House of Lords. This court approached the case primarily in terms of conforming interpretation, and one can see that from the headnote. That's at bundle 4 of the authorities, behind tab 44 at page 897.
Yes.
And on page 897, between F and G in the headnote, one sees it stated that the issue on the appeal was inter alia, whether a proper transitional period could be implied or read into Regulation 29(1)A, where no transitional period was provided by the legislation. And that theme can be traced through the judgments, and I'll do this at a canter, if I may. At page 913 in the judgment of Lady Justice Arden at paragraph 38, Lady Justice Arden said the real issues in this case, this is between C and D, the real issues in this case are whether community law would recognise or imply, or both, a notional transitional period, that is, one not specifically set out in legislation, and also by reference to what event should that period be fixed. At 915 in paragraph 44, right at the bottom of the page under J, Lady Justice Arden says she would reject Mr. Southern's primary submission that no transitional period can be implied, as he put it, into Regulation 29.1a, or, as I would prefer to express it, read into Regulation 29.1a. There are more references to reading in or giving effect to a transitional period in paragraph 57, which is at page 919. Yes, at page 919, one sees it in particular at D. If one moves on to the judgment of Lady Justice Hallett, who says she restricts her observations, this is in paragraph 59 on page 919, to one issue, which is whether or not the court has the power to imply or read into Regulation 29.1a, an adequate transitional period when none has been provided. At 65, on page 921 at H, she says she derives from Guydan the principle that however strong and radical the obligation on the court to interpret legislation, there is a line that the courts may not cross. And she says, I don't recall Guydan, concerned as it was with the Human Rights Act 1998 being cited to as an argument, but I'm sure Ms. Foster would not wish to argue against that proposition. And in the following paragraph 66, again, she's referring to the duty being to read legislation in such a way that it gives proper effect to community rights so far as possible, and goes on to say she can't accept that there's a Litster type situation. I can't accept, she says, the legislation here can be reasonably construed as incorporating a transitional period where none was provided or contemplated. In my judgment, it's simply not possible to do so, however broad or robust an approach the court is obliged to adopt. And then there are similar references in 67 and 68 to it being inappropriate to legislate judicially to the extent required here. There's no provision to be given a purposive construction, that's at 67. At 68, if we're not entitled to read the regulation in such a way that a transitional period is implied or read into it. And then similar points can be made in respect of Lord Justice Ward's judgment at 72 on page 922, at page 80 on page 924. It comes as a surprise to me to imply a reasonable transitional period in legislation which provides none. This is at F. Whilst the benign purposive construction of an inadequate transitional period may possibly lead to the implication of a period of grace which is just to be reasonable, I simply cannot see how one construes something out of nothing, and if it were possible, Marks and Spencer's would have been decided differently. And then at 81 and 84, one sees Lord Justice Ward expressing his view in terms of disapplication because the failure of the commissioners, this is at 81, to include any transitional limits is fatal to their case, and at 84 I have difficulty in seeing, this is at 925 between D and E, I have difficulty in seeing how a transitional period can be implied or read into a regulation which eschews any time limit at all. Now, if one goes over to tab 45, which is the decision on the Fleming of the House of Lords, it's right that the House of Lords dealt with the case as one of disapplication, although it's fair to say, without going into detail as to why they approached it only on that basis and not also in terms of conforming interpretation, although one sees at paragraph 25 on page 938, at the top of the page between A and B, Lord Walker saying, in these two appeals it's common ground, at least in your lordship's house, that the National Court is concerned with disapplication, not with trying to find a conforming construction. This important distinction has been to some extent overlooked in the Court of Appeal. But I think our position on that would be this, and it's a point I've trailed already. One only gets onto disapplication if a conforming construction it isn't available.
Mr. Mulder, isn't the obvious inference from that paragraph that HMRC didn't appeal against the Court of Appeal's decision that no conforming construction was possible.
Well, that may well, with respect, my lady, that may well be right, but
So one's an issue before the House of Lords.
well, on the basis, one can infer that it was approached only in terms of disapplication because the revenue didn't seek to maintain the stance that a conforming construction was available.
Yeah. So the House of Lords decision isn't authority on the question of conforming construction because it wasn't an issue before them.
No, but with respect, many of the points, and I think this has been trailed by Mr. Johnson, many of the points in terms of the limits on conforming construction will also bite, we say, in relation to disapplication. For example, in terms of legal certainty, because, as I say, I mean, the overarching submission is that it's very difficult to see how one gets to a kind of disapplication with precisely the same effect as a conforming construction which has been held not to be permissible because it contravenes general principles of EU law. In any event, I wasn't going to say very much more on Fleming because you've been taken to the speeches of Lord Hope, Lord Scott and Lord Newburger by Mr. Johnston. Can I just mention, really for the transcript or for your note, what Lord Carswell said at paragraph 77, which is at Authorities 4, tab 45, pages 955 to 956, where he agrees with Lord Hope and Lord Newburger that it's for Parliament or for the Commissioners who must disseminate the information sufficiently to all value-added taxpayers to introduce prospectively an adequate transitional period. And so far as Lord Newburger's speech is concerned, you were taken, I think, to paragraph 85, and can I also mention paragraphs 86 to 88 and 90 at pages 958 to 959 of the Authorities Bundle. My ladies, my lord, I was going to move on then to touch again very briefly on FII Supreme Court 1. In that case, the Supreme Court rejected the Court of Appeal's ruling that the restrictive condition in section 33(2)A of the Taxes Management Act to the effect that no redress was available where tax had been paid, albeit mistakenly, in accordance with the practice generally prevailing at the time of payment, was capable of being given a conforming interpretation so as to be read subject to the limitation that it applies only if and to the extent that the United Kingdom can consistently with its treaty obligations impose such a restriction. This was held to go against the grain of the legislation on the basis that the prevailing practice rule was a cardinal feature of the legislation. And I was simply going to draw your attention, if I may, still in Authorities Bundle 4, but behind tab 50, to what was said by Lord Sumption at paragraph 205, which starts at the bottom of page 1238. And there, under G, he says the Court of Appeal held that Section 33 did impliedly exclude a right of action at common law, even in relation to claims to tax overcharged contrary to EU law. They then dealt with the resulting inconsistency with EU law by reinterpreting the section so as to remove the offending restrictions and the element of discretion. I think that this was wrong in principle, and I place particular emphasis on this. I very much doubt whether such radical surgery can be justified even under the extended principles of construction authorised in Mar leasing. Its effect would be fundamentally to alter the scheme of the provision, but however that may be, it seems with respect eccentric to imply an ambit for Section 33, which is inconsistent with EU law, and then to torture the express provisions so as to deal with anomalies that, but for the implication, can never have arisen. So again, there's an example of an instance where the bounds of a conforming interpretation were stretched possibly beyond their proper limits. I'm going to deal now, if I may, again briefly with Routier, which is in bundle 7 of the authorities. And I keep in mind the observation made by Lord Justice Miles yesterday on this. But in any event, Routier, which is behind tab 65, beginning at page 1979, is concerned with, as we know, section 23 of the Inheritance Tax Act. That restricted the exemption from inheritance tax upon dispositions on trust for charitable purposes, dispositions in favour of UK-registered charities, and in that way contravened the principle of free movement of capital. The case law of the Court of Justice established, however, that restrictions upon the movement of capital could be justified on the basis of the prevention of tax avoidance, so that restrictions which were limited to capital movements to and from third countries without exchange of information agreements, tax havens, with the member state concerned could be proportionate. Routier was concerned with a Jersey charity. Jersey didn't at the time have such an agreement with the UK. Now, the Court of Appeal gave a conforming construction to Section 23, permitting relief to be given relevantly, where the relevant charity is based in an EU country or a third country which has an information exchange agreement with the UK. That's referred to in paragraph 49 of the Supreme Court's decision at pages 1998H to 1999A. And in so doing,
I'm so sorry.
not at all. It's bottom of 1998 at H, paragraph 49, to the top of page 1999.
Thank you.
And in so doing, it sought to alleviate the limitation of the relief to UK charities alone, but to the limit perceived to be required by EU law by excluding those located in countries without a mutual assistance agreement. And one sees that from 54 over at the bottom of page 90, on the bottom of page 1999, the Supreme Court rejected that approach, saying this: with great respect to the Court of Appeal, it shouldn't have concerned itself with a hypothetical restriction concerned with the existence of mutual assistance agreements, even if it considered that such a restriction might have been justifiable under EU law and might have been imposed by Parliament. The fact was that there was no such restriction in existence. Neither Section 23 of the Inheritance Tax Act nor Section 989 of the Income Tax Act made relief for trusts in third countries conditional on there being a mutual assistance agreement in place. It's really these words that I place reliance on. The fact that such a restriction, if it existed, might have been in conformity with EU law did not mean that it could be imposed by the court by means of a purported interpretation of the language used in Section 23. So just pausing there at paragraph 154 of its decision, the Upper Tribunal dismissed the relevance of that guidance for the purposes of this appeal. And we respectfully submit, with great respect, the Upper Tribunal was distracted in that respect by an irrelevance. The limitation in Section 23, as was remarked yesterday, came about by way of a so-called judicial gloss of long-standing, which interpreted charity for the purposes of the predecessor legislation as UK-registered charity. And it was that judicial interpretation which created the restriction of the exemption to UK charities only. But we say that the Upper Tribunal, with respect, was wrong to regard that as a decisive point of distinction for two reasons. First of all, it can be said that the judicial interpretation of a provision doesn't amend it. So if the House of Lords tells us in Dreyfus that charity means UK charity, then that is what the legislation means. But secondly, and perhaps more importantly, the Supreme Court's guidance, we say, extends beyond the question of statutory interpretation. If Section 23 had expressly referred to a UK charity, the answer would still have been to strike through the words UK registered. There's no indication of any intention to limit the guidance to cases of statutory interpretation. And on that basis, we respectfully submit that Routier stands for the proposition that since the UK legislation could be made compatible with Article 56 by simply disapplying the relevant restriction of the treaty freedom, and on the provisions as they stood, the taxpayer would otherwise meet the requirements under the UK legislation, there was no basis for reading in further conditions which would have been permissible under EU law, but were not in the provisions at the time and were not mandated by EU law. And nor, we say, was it relevant that the UK could hypothetically have included such further conditions relating to the existence of information exchange agreements, because at the time the only restriction actually in force, so to speak, was the Dreyfus gloss, and the simple solution was to disapply that.
Well, Mr. Markham, would you accept that this case is really about not an amendment to legislation, but about the disapplication of an interpretation of the legislation by the court, because the words of the legislation, taken on their own, were fine.
Well, my lady,
how can the reasoning in this case be extended to a case which is concerned with the wording of the legislation rather than with a judicial gloss on the language of legislation?
Well, because what the Supreme Court identified was that it was neither necessary nor appropriate for the Court of Appeal to have read in, and I am going to call it a scheme, but a regime or a framework into the legislation to cure the problem on the basis that that was its perception of what EU law, of the approach taken by EU law, or the minimum requirement of EU law as regards the protection of the relevant treaty right. I mean, it's obviously not a precise...
The approach of the Supreme Court was different from the approach of the Court of Appeal. Because the Court of Appeal read in a lot of stuff, and the Supreme Court said, no, the answer to this is that the judicial gloss is wrong.
But it did also, my lady, these were the words I laid emphasis on in paragraph 54 on page 2000, it did also say the fact that such a restriction, if it had existed, might have been in conformity with EU law, did not mean that it could be imposed by the court by means of a purported interpretation of the language used in section 23. So it may stand as
is that essential to the Supreme Court's reasoning?
Well, in the sense that the deletion, if you like, of the gloss was, it said all that was required, one might say no, but then that's answered to a degree at least by my first point, which is to say that it can be said that the judicial interpretation provision doesn't have the effect of amending it. It's been referred to as a gloss, but what the House of Lords had said in Dreyfus meant that, as a matter of English law, charity in section 23 meant UK registered charity.
Right.
But that's in any event all I was going to say in relation to Routier. I had intended to address the court on IDT and Vodafone too. You've been taken to those decisions of this court by Mr. Johnson. I'm not going to ask you to look at them again. Can I just mention, though, for the transcript and for your note, my ladies, my lord, what Lord Justice Longmore said in Vodafone 2 at 71. So that's Authorities, Volume 4, tab 47, and it's at page 997, where he said the words which HMRC suggests should be inserted into the Act to ensure its compliance with Article 43 of the EU Treaty do not create a new and different scheme, nor do they offend against any of the Act's cardinal principles, still less do they remove the core and essence of the Act. The proposed insertion merely adds a further exemption, which is allied to, although different from, the exemption granted to subsidiaries created or used without the motive of reducing the United Kingdom company's liability to tax. So that rather pithily touches on a number of our main themes in terms of going against the grain, in terms of offending against an Act's cardinal principles, removing its core and essence, inserting a new and different scheme, and by contrast, merely adding a further exemption allied to the exemptions within the pre-existing framework.
And could you just remind me which paragraph was that?
Paragraph 71.
Thank you.
Is that reasoning part of the decision of the court, or is it an observation in a concurring judgment? Because Lord Justice Golding says, I also agree. He doesn't say, I agree with both judgments.
Forgive me, my lady. Can I just see if I can answer that?
Sure.
Well, Lord Justice Longmore says at 72 that it follows that he agrees with the reasons given by the Chancellor, and then Lord Justice Goldring also agrees.
Yes, but he doesn't say, I agree with both judgments. That's the point of my question. Normally, when the third LJ agrees with both judgments, he or she says so. That's all I'm asking. Are we to infer that he agreed with both judgments or not?
Well, your ladyship is a far better position than me to indicate how justices of this court expressed themselves in that context. But I had taken it, perhaps wrongly, that Lord Justice Goldring was agreeing, well, either agreeing with both judgments, or that Lord Justice Longmore's reasoning was consistent with what we'd seen in the judgment of the Chancellor, albeit perhaps expressed in, as I say, a particularly pithy form for my purposes. But it may be that he's delivering a concurring judgment and Lord Justice Goldring is agreeing with the Chancellor's judgment.
Yes, all right. Thank you.
They're really a different set of metaphors, aren't they?
I'm sorry, my lord.
It's a series of metaphors, really, isn't it? You've got going against the grain, core and essence, cardinal principles. There are a series of images that different judges have used, which are essentially expressing the same general idea. Is that your submission, or do you say they're different?
No, I don't think I'm disagreeing, my lord. It may be that part of the value of, I don't want to seem to be describing them pejoratively by describing them as sound bites, but sound bites or metaphors or headline descriptions of some of the cardinal principles engaged in this area of law are sort of distilled in rapid succession by Lord Justice Longmore. But I do lay particular emphasis on his reference to the words sought to be included, not creating a new and different scheme, and merely adding a further exemption. And those observations in my submission are entirely consistent with the points which have been made by the Chancellor in his judgment. I was going to move on then to legal certainty and the protection of legitimate expectations, essentially to do with matters of law. But I don't want to take too much time on this. But I thought it might be helpful just to give the court the references in our skeleton, which go to a point that occurred during the course of my submissions yesterday, as to the consequences, as it might be said, of the first-tier tribunal's finding that, irrespective of counsel's advice, Redevco would have migrated. And on that, a rather clearer statement of Redevco's position than I was able to give yesterday can be found in our skeleton before this court. Perhaps I can just give you the paragraph and page references. At paragraph 22B, which in our replacement skeleton argument is core bundle 1, tab 13, and it's page 223. We say there, in any event, that the Upper Tribunal misunderstood Redevco's argument and the FTT's factual findings, that Upper Tribunal 157 misapplies the finding in FTT 26 that the migration would proceed irrespective of leading counsel's advice. The FTT found the advice, which was wholly favourable if obtained for insurance purposes after the decision to migrate had been made, FTT 15 to 16. Upper Tribunal 157 wrongly uses FTT 26 to suggest that the decision to migrate would have been taken irrespective of what the legislation said. On the contrary, FTT 25 concluded that tax considerations were part of the decision to migrate. And then just very briefly to give you the reference to what's said on page 226 in paragraph 5 about the instructions to counsel and the context. I think I did use the word context yesterday, the context of the advice sought and the FTT's findings, that context including the overwhelming view amongst tax practitioners at the time. And then paragraph 18, which is on pages 231 to 232, where we say that the Upper Tribunal went further in its reasoning than the finding of the FTT warranted. I'm not going to say any more than that, but I hope that gives a better answer to the point that arose yesterday than I was able to give at the time.
Well, the problem is in this skeleton, you've taken the reference to the tax advantages or tax considerations and built on that and said, well, it shows that they were concerned about this very issue, and this was therefore in some way part of the decision. But yesterday we discussed this, and the tax considerations and tax advantages seem to be something else, i.e. not the idea that your clients would not have to pay this exit tax. There were other tax advantages and tax considerations. And the FTT, as we were looking at it yesterday, appeared to say it didn't matter what counsel advised, you would have gone anyway.
And if I can, as I say, I don't want to take too much time on this, my Lord, if I can try to put that in context so that the court can understand how we make this submission. The FTT's conclusion that it was more likely than not that Redevco would have migrated whatever counsel's advice was reached on the basis of its view of the contemporaneous documentation before it. And one gets that. That's at core bundle 8. It's paragraph 26, the bottom of page 138. Said that although the evidence of Mr. Drury that the decision to migrate was not a foregone conclusion, and that of Mr. Faber was that migration would not have occurred if Redevco had not received positive advice from leading counsel, contemporaneous documentation doesn't support such assertions. As such, I find it's more likely than not that the migration would have proceeded in any event, irrespective of the advice of leading counsel. Now, just on that, the contemporaneous documentation referred to, if one goes back to page 132, it includes, one sees, starting at paragraph 15 on that page, references to the instructions to counsel prepared by PwC. And that's the document that says, depending on counsel's views as to the prospects of success, Redevco may seek to insure against the risks of litigation. And then in 16, it said that there's no indication in the instructions that the decision as to whether the migration would take place was dependent on the opinion of counsel. The context in which that advice was sought, and one sees that's confirmed by leading counsel, was that the overwhelming view amongst practitioners at the time was that the UK legislation was unlawful. And one can see that in the advice, which is at supplemental bundle tab 9, page 79.
I'm sorry to interrupt you, but what are we doing? We can't remake the facts. The facts have been decided long ago, and the conclusion is reached in paragraph 26.
My lady,
and it's reached on the basis that's set out in paragraph 26, including contemporaneous documentation. You've taken us back to 15 and 16, but it all turns, doesn't it, on that last sentence, irrespective. So tracing through, for my part alone, I don't see how that helps us.
My lady,
Perhaps I'm being obtuse.
I'm certainly not going to suggest that. I'm simply going to say
We didn't challenge his findings, I understand, is in the Upper Tribunal.
well, there was an Edwards and Bairstow challenge which wasn't pursued, and as to which the Upper Tribunal said it would have in any event rejected. All I'm trying to do is to put the finding in 26 in context, the context including what's said at 15, 16, and 18 about the contemporaneous, and 17, about the contemporaneous documentation, advice not being sought from other sources, and so on, to explain the purpose for which it seems counsel's advice was being sought. And that puts in context in my submission the way in which the tribunal came to its finding and the finding that it came to as to the fact that Redevco would have migrated anyway, irrespective of that advice. It didn't hold, and we say, with respect, and notwithstanding my exchange with my Lord Justice Miles yesterday afternoon, that the Upper Tribunal went too far in extrapolating from that finding, which was concerned with counsel's advice, that actually Redevco would have migrated irrespective of what the legislation said. And that's, we say, explained by the context in which counsel's advice was sought. And I'm not proposing to say any more on it.
Thank you, and we gain that from what is set out in those paragraphs of the FDD.
Well,
That's the background.
One sees the context in which counsel's advice was being sought.
Yes.
And I was going to give the reference to supplemental, we're not going there now, supplemental tab 9, page 79, paragraphs 4 and 6 of the advice, which explain that context, and we would say the universal or near universal perception of practitioners at the time, prior to counsel's advice being sought.
The other thing we need to bear in mind, Mr. Marvin, is that these findings of fact were made specifically in the context of the legitimate expectation argument. And if you haven't relied on any legitimate expectation because you would have gone anyway, isn't that the end of the legitimate expectation argument?
Well, my lady, I think I can only reiterate the point that I've been trying, perhaps struggling to make in terms of the distinction between the finding in relation to counsel's advice and the absence of any finding as to what Redevco would or wouldn't or might not have done if the legislation had been in an EU law compliant form in the first place. But I'm at risk, I think, of repeating myself. But that we say is a crucial distinction. Can I turn then to the law in this regard? And hoping I can deal with it relatively briefly. The principle of legal certainty, which we say includes the protection of legitimate expectation and also takes in issues relating to retroactivity in certain circumstances, explains, in the words of Professor Tridimus, which are actually referred to at paragraph 57 of the First Tier Tribunal's decision at Core Bundle, page 148, expresses the fundamental premise that those subject to the law must know what the law is so as to be able to plan their actions accordingly. If one goes briefly to Bundle 4 of the authorities at tab 50, FII SC1, and if one goes specifically to at the bottom of page 1212, what one sees Lord Sumption discussing the the curtailment of an existing limitation period giving rise, he says, to special considerations. There are two objections that might in principle be taken to it. First, even if the change applies only to future claims, it's likely to operate retrospectively to some extent. And then at B, he goes on to say the second potential objection is that to the extent that the change is retrospective, it may offend against the principle of legal certainty. People must be taken to appreciate that the law may be changed, but until it is, they're entitled to organise their affairs on the basis of the law as it stands and to assume a sufficient measure of predictability in its future development to enable them to exercise their EU law rights. This objection is, he says, below C, commonly analysed as depending on the principle of the protection of legitimate expectations. This isn't really a distinct principle. It's been described as the corollary of the principle of legal certainty, which requires that legal rules be clear and precise and aims to ensure that situations and legal relationships governed by community law remain foreseeable. And then at E, and I emphasise this, it's one manifestation of the broader principle that those subject to the law should be able to ascertain their rights and obligations at the time they're called on to decide what to do about them. Now, you have my submission already, that whilst we accept that as the Chancellor observed in Vodafone 2 at 56, a conforming construction is inherently retrospective, particular care must be taken in certain circumstances, including where rules entailing financial consequences such as tax law are involved, not to infringe the requirements of certainty and foreseeability. If I could just ask you, please, to go to Authorities Bundle 10.
Do you accept, Mr. Marvin, that there's a difference in principle between the limitation period that is or isn't set out in primary legislation or secondary legislation, and the relaxation of the rule in the statute, which is what was done by the FTT and the Upper Tribunal?
First of all, I accept that they're obviously very different situations in terms of the facts, and I would seek to emphasise the importance, the commercial importance of the decision to migrate that was being taken here. So far as relaxation is concerned, and it's a point that's cropped up in a slightly different context and argument already. This is obviously an unusual situation because the revenue are saying that actually they're doing us a favour. But you have my learned friend Mr. Johnston's submissions in relation to the absence of any choice at the time, and inextricably linked with that, we would say, is the notion that a party needs to be able to ascertain with clarity what the law is in order to make decisions prospectively. Although the revenue might say, I'm obviously paraphrasing their case, that they're doing us a favour here. Of course they're not, because we say that the appellants in these appeals were entitled to take a view of the law as it was, and that it stretches principles of conforming construction or disapplication beyond their proper bounds so as to contravene principles of legal certainty, to rewrite in measures which no one is suggesting, as far as I'm aware, were foreseeable at the time.
Right, all right, that's very clear, thank you.
When you say they're not foreseeable, do you mean that no one had actually formulated them? Is it that hard to foresee?
Well, I think it's, my lord, I think it's quite hard to foresee what, if any, conforming construction might be sought to be applied many years after the event. What one can see from looking at, I think, the note of leading counsel's advice and the Law Society paper is that there was some discussion at the time as to what might be done to cure the breach, although we say that was in terms of what legislation might then be enacted, and in the event was enacted, to put in place compliant measures.
That's the same sort of thing, isn't it? for the legislature to make changes, it would be doing that in order to comply with European law principles.
So, my lord, I agree that to that extent, or in that respect, it's a similar sort of thing, but it's a very different sort of thing in this respect, which is to say that legislation, subject obviously to some relatively limited and established exceptions, particularly in the tax sphere, is prospective, and the terms of legislation are, or should be, clearly apparent from its terms. What might be imposed retrospectively by way of a conforming construction 15 years later is a different thing, in my respect for submission, from express legislation to remedy the breach of EU law.
But isn't the
Go ahead.
isn't the end result of your submission that in fact it's never possible for a court to formulate a conforming construction in accordance with EU law, because that will always be different from what is on the tin, on the face of the legislation as it stands? And isn't the effect of your submission that, in effect, therefore, the only means by which the legislation can be conforming is, in fact, not to conform, but to disapply? You're left only with disapplication, because otherwise you're always creating, you would say, something which is different and therefore offends legal certainty. Isn't that the ultimate terminus of your submission?
Well, with respect, my lady, and perhaps unsurprising, my answer is no. There is the strange feature of this case, which I've just been touching on, that this is a situation where the revenue say that they are actually relaxing provisions for our benefit, but they're not really. They're retrospectively rewriting provisions to our disadvantage.
Well, only in the sense that you'd end up having to pay the tax.
Well, yes, but
that when they say it's a relaxation, as I understand the submission, it's that you give the legislation a conforming interpretation which relaxes it in the sense of saying that instead of having to pay all in one go, you can pay in instalments. It's a relaxation in that sense. Now, of course, the legal consequence of the argument is that they can claim the tax when they wouldn't otherwise be able to. But it can't possibly be an answer for you to say, well, it offends legal certainty because I now have to pay the tax.
well,
Which is really what you're...
Well, I think it is the burden of my
you say
argument.
they're not being generous to you because they're trying to impose tax on you. Well, that goes without saying. But it doesn't really meet the question of whether what's happening is a form of relaxation of the, as it were, the express obligation under the statute.
Well, they're obviously trying to impose the burden of the tax on us, as one would expect them to, in circumstances where we say that the legislation on its face at the time was, as is now common ground, incompatible with EU law.
Unless it conforms.
Unless it conforms, but it can only conform in a way which we say was not foreseeable and certainly not foreseen in terms of a conforming construction at the time. And that it's wrong for my client to be in a position of being taxed on the basis of legislation rewritten many years after the event, when it had to take the decisions that it took on the basis of its perception of the legislation at the time. But I accept that this is a very unusual set of circumstances because, as a matter of fact, my client didn't pay the tax for many years. It has now paid the tax. And so what the revenue said, in fact, in some of the earlier correspondence, I don't want to give evidence, but, well, actually, we can deal with this under our care and management powers, or you've had, in effect, the benefit of a deferral. One answer to that is my learned friend Mr. Johnson's point about a choice at the time, but there is also, in my submission, a broader answer in terms of legal certainty and whether it's right retrospectively to impose a burden which is the practical effect of the conforming construction that's been adopted here, retrospectively to impose a burden which on the face of the legislation did not exist at the time. And that is an unusual set of circumstances which takes us, I would say, outside the norm, which is why, in my respectful submission, that the terminus of my argument isn't that a conforming construction is never possible. The distinction between the normal run of cases and this one is that in the normal run of cases, a conforming construction is adopted in order to safeguard the rights of the taxpayer or whoever. In this case, it's said to be sought to be done with that effect, but actually the effect is the very opposite, because the taxpayer is disadvantaged by retrospectively legislating judicially, as we would say, in circumstances where it could only have taken the decisions that it took at the time on the basis of its analysis of the legislation as it then stood, not something devised after an inquiry or during the course of an inquiry lasting many years and formulated in various iterations over a number of years, many years later. And the court's heard something similar in relation to the evolution of the Commissioner's case in the Panayi appeals as well.
May I ask you a question, please, Mr. Mobley? It's a hypothetical question. Would you have had a complaint if Parliament, when it amended the legislation, as it eventually did, had done so with a retrospective effect?
I think we might well have done. But there's a not insubstantial corpus of law in relation to retrospective legislation, particularly in the EU law context, which I'm not going to claim to remember to the extent that I knew it, but I'm pretty sure that my client would have had a complaint. And as we've seen in some of the cases here, I mean, there are issues about transitional periods and the reasonableness of transitional periods, as opposed to imposing legislation with either immediate or directive effect, and issues of that kind, I suspect, would have been involved. But in any event, that's not what happened here.
No,
obviously.
I understand that, but in principle, it is open to Parliament if it makes its intention clear enough to legislate with retrospective effect.
If it makes its intention clear enough.
Okay.
But there is a certain amount of law, including EU law, on that very point.
Sorry to ask you a different question, but it's helpful to us, obviously. At the time when you migrated, was there actually EU, European Court authority, saying that exit taxes were contrary to the freedom, or was that just a view that was prevalent?
There were some cases in relation to individuals, and I think one can actually see that. I did mention before, I think, supplemental bundle, I think it's page 79. Is it 79? Yes, at 79, so this is in the note of the con with leading counsel in December 2006, and there's a reference there in paragraph 4 to exit charges having been considered in 2 cases concerning individuals. De Lasterie, I think we saw a reference to De Lasterie du Saillon yesterday concerning French exit charges, and N concerning exit charges in the Netherlands, and then you'll see what counsel's view was in paragraph 5 about, to put it in a very brief summary, about a similar approach. In respect of the court.
Thank you. You're taking us, I think, to the 10th volume of authorities.
I've just noticed
yes.
paragraph 7 counsel's advice, he seems to have anticipated that the most likely response of HMRC would be to have a trailing exit charge, which should tax a company which has ceased to be resident on disposal of UK assets within a period of 3 to 5 years, or at most 6 after migration.
So I'm just going back to the file. I think our point on that is explained or supported by the previous sentence. Council Addy believed that HMRC understood the weakness of the UK exit charge legislation in its current form under EU law and are undertaking a review of the changes which will be required to make it compliant. And our point on that was that's reasonably to be understood as HMRC looking into what legislative changes need to be made to render the UK legislation compliant. Not, sorry, forgive me.
But what council anticipated at the time is evident from the next sentence.
That's my lady, yes. That's a different thing in my submission from leading counsel having said, and indeed he does not say, and that is something which can be, which there is any risk of being imposed retrospectively, either by Parliament or still less by way of a conforming construction of some other part of the tax code.
All right, thank you.
But there doesn't seem to have been any discussion at that point.
No.
And he doesn't seem to have been asked the question either about conforming interpretations.
No, and I mean I don't want to.
It seems from reading the instructions that he was asked a rather limited question, which is it compatible with EU law as it stands? But there doesn't seem to have been a follow-up question of what would happen in terms of conforming interpretation. But everyone knew about conforming interpretations by this time.
Well, they did, but I again, I don't want to give evidence on this. I'm not in a position to. But I'm not sure whether the notion of giving a conforming construction of the kind adopted here, and specifically in relation to other aspects of the tax code, quite remote from the charging provisions that were being considered. I'm not sure that the notion of giving a conforming construction in that way would necessarily have been in the minds of tax practitioners at the time. I completely accept that conforming construction was an established concept by that time, but this was, as one notes from the date of the con, it's 20 years ago. So I think things may have moved on to a degree by then. That, of course, is not to say that the doctrine of conforming construction doesn't have the same effect now as then, but it might explain why there's no discussion of it in the instruction or in the note of counsel's advice. But I fully accept it's not something that's discussed there. Sorry, yes, I was going to ask the court to look at Authorities Bundle 10. And it's behind tab 96. The case of car transpedition. And I was simply going to ask you to look at paragraph 55 and 56. And that's the bottom of 3107 and the top of 3108, which simply record the established principle of EU law, that the principle of legal certainty the corollary of which is the principle of the protection of legitimate expectations, and compliance with which obliges member states to lay down the conditions in regard to exemptions, requires on the one hand that rules of law must be clear and precise, and on the other that their application must be foreseeable by those who are subject to them. 56, that principle must be observed all the more strictly in the case of rules liable to entail financial consequences, in order that those concerned may know precisely the obligations which such rules impose on them. It follows that it's necessary that taxable persons should be aware before concluding a transaction of their tax obligations. And I'm not going to ask you to go there, but can I just give you, for the transcript and your reference, a couple more references on that point. The first is to Lady Justice Arden's judgment in IDT at paragraph 110. So that's at Authorities 3, page 889.
Sorry, which tab in volume 3, please?
Forgive me, it's tab 43. I wasn't asking you to go here, but it's volume 3, tab 43, page 889. The words I rely on are, I accept that under the principle of legal certainty, the person affected by legislation must be able to foresee the manner in which it's to be applied, and I'd also accept that that must be particularly so where the legislation has financial consequences for him, such as flow from the imposition of the requirement to account for VAT. As we saw yesterday, Lady Justice Arden went on to say that the principle of legal certainty wasn't infringed in that case, because it's well known that the provisions of the VAT Act have to be interpreted in conformity with the Sixth Directive, and the supply of telecommunications services constitutes a taxable supply for the purposes of the directive. Can I also give you the references for, I don't think they take things perhaps very much further forward, but they're further demonstrations of the application of those principles in EU law and in domestic law. The first case is impact, which is often cited in this regard. It's at paragraphs 93 and 100. So that's at Authorities, volume 9, tab 86, pages 2826 and 2827. And the way in which these various statements were picked up by the Supreme Court in FII Supreme Court 3 in the judgment of Lord Reed and Lord Hodge at 143. So that's Authorities 7, tab 68 at page 2134, where they recite that it's necessary to bear in mind the obligation to interpret national law in conformity with the requirements of EU law is subject to the qualifications explained in European cases such as Kolpinghuis and impact. So all of those authorities stand for the proposition, which I'm not sure is actually in dispute, that the court's approach to conforming interpretation, and we would say that its application as well, is controlled by and limited by legal certainty rather than vice versa. And we say with respect that the approach taken by the Upper Tribunal in this case reverses that order of priority. And indeed, those cases, to the extent relied on below, weren't referred to in this connection in the Upper Tribunal's decision. Lastly, on that point, you were taken, I think, briefly yesterday to Verda Labtech, which is one of the cases dealing with exit charges in the Court of Justice in the corporate context. There, and the reference to the judgment, although we don't need to go there, is Authorities 10, tab 92, starting at page 2990. There, the immediate exit charge arose as a result of an earlier judicial ruling. The domestic tax authorities, in giving effect to that ruling, had, as a matter of administrative practice, allowed a 10-year payment period. The German legislation was later amended explicitly to introduce a charge with a 5-year payment period to reflect intervening CJEU case law developments. The National Court's question that was referred asked about the legality of a charge with a 5-year or a 10-year payment period. And the CJEU held the question to be inadmissible so far as the 5-year period was concerned, since there was neither any legislation nor administrative practice applicable at the time which permitted a 5-year deferral period, and it confined itself therefore to the 10-year period only. There was no suggestion that a 5-year period might somehow arise retrospectively under the leasing principle. And then finally on this as a sort of
That wouldn't have
subset.
been a question for the European Court, would it?
No.
That would be a conforming
That's a matter for the
for the
National
German
Court.
court.
But there was no suggestion in the reference from the National Court that was a potential answer. Finally, as a subset of this heading of my submissions, there's the notion that you'll get from, amongst other places, my learned friend's skeleton at paragraphs 2.4 and 35.5, relying in particular on Vodafone 2, that the Upper Tribunal's conforming interpretation, as it's put, faithfully follows and implements the jurisprudence of the CJEU. I've just two very quick points in response to that. The first is that we say, as the cases including impact show, that EU law requires conditions to be set in advance. It would permit deferment until realisation as well, it seems. Deferred payment by five instalments, forgive me, is just one possible option. So to that extent, there's nothing faithful about it. It's simply another attempt to second guess what the minimum permitted by EU law would be, not done out of loyalty to the EU, but to prejudice the appellants. But secondly, and perhaps more relevantly in the context of legal certainty, and it's something which was touched on during the course of submissions yesterday, of course, the EU case law on which the commissioners rely postdates Redevco's migration for a number of years. DMC was decided in 2014 and Verda Labtech in 2015. So we say if one stands back on HMRC's case, they stand to benefit from, and Redevco stands to be seriously disadvantaged as a result of the fact that the inquiry was so long drawn out. And if this case had been in the tribunal in 2010, or even any time up to 2013, one might say, the ability of the commissioners effectively to play catch-up by reference to intervening Court of Justice developments wouldn't have been available. Subject to the court, that's all I'm going to say in relation to legal certainty. As regards judicial legislation, we respectfully adopt Mr. Johnston's submissions on the proper role of the courts and respectfully submit that the conforming construction adopted here strays beyond that into judicial legislation. You've heard from him and from me, in particular, by reference to what was said in Fleming about this. I was simply going to mention, but I wasn't going to ask you to go there now, what was said by Judge Beer in the First Tier Tribunal in Gallagher. So that's Authority 7, tab 64. It starts at page 1873, but the relevant paragraphs are 212 and 219 to 220, which are at pages 1948 to 1950. On the Constitution.
212 and...
Forgive me, so it's 1949 to 1950, yeah. Paragraphs 212 and 219 to 220.
Thank you.
Where he, referring back to observations made in Guiding and in Fleming, discussed the constitutional constraints on the tribunal's ability to choose from a range of potentially conforming interpretations in a similar context. Now, of course, that's rather been overtaken by events in the sense that the issues in these appeals have now progressed to this court. But there is, in my respectful submission, much to be said for the restraint exercised by Judge Beer in Gallagher on the basis of the constitutional limitations by which he considered himself bound. And very lastly on that point, and I think this has been trailed to a degree by my own friend Mr. Johnston, the need to exercise, we would say, such restraint as regards engagement in what might be termed judicial legislation is particularly acute where it might be said, as here, that the interpretation contended for is contrary to the express will of Parliament. Now, as I mentioned yesterday, Schedule 3ZB was to be treated under the provisions of the Finance Act 2013 as having come into force on the 11th of December 2012 in relation to an accounting period if the relevant day fell on or after that date. And it might be said that if Parliament had considered it appropriate to introduce the regime with an additional element of retrospectivity, then it could and presumably would have done so. And to that extent, at the very least, although we adopt my learned friend Mr. Johnston's submissions more generally on this, it can be said that the Revenue are inviting the court to adopt an interpretation which is contra legem or appears to be against the will of Parliament or indeed against the grain or thrust of the legislation. And I think you might not have been taken to Dansk Industry, but you were taken to the Ample Award case. I'm going to take, if I may, my last 2 points slightly out of sequence with both eyes on the clock. Just to say something more in relation to disapplication before I move on to deal with the slightly vexed question of interest. The court has the bulk of my submissions in relation to disapplication, which are based on Fleming. And I was simply going to add 2 further observations to what I've said already. The first is, and you heard in some detail from Mr. Johnston on this point, and I would respectfully re-echo his submissions. The first is where the offending part of the legislation is to be found, what it is that represents the restriction on our EU law rights. And we say that the restriction, and hence the offending legislation, is the charging provision. That was the source of the interference with the right of freedom of establishment. That imposed the lawful burden. And you were shown yesterday by my learned friend the Advocate General's opinion and the Court of Justice's decision in Panayi, which we say make good that submission. There was no discussion there, and no reference there at all to Section 59B, or as it would be in our case, Section 59D of the Taxes Management Act, in analysing the incompatibility of the UK tax regime with EU law. So we would say, in terms of disapplication, logically, the relevant disapplication, if possible at all, should be of the charging provision itself, not Section 59D. But secondly, even if the proper focus of the disapplication were in Panayi, Section 59B and Section 59D in our case, it doesn't really make any sense to talk about disapplying those provisions with the result that the tax is payable in instalments. We say, and this goes back to our submission on Fleming, in reality that's not disapplication at all. What it is the reading in of new language, whether that's referred to as a scheme or not, which, for the very reasons which we've submitted on the basis of Fleming, would be wrong in the context of conforming construction, would also be wrong for the same reasons as a way of trying to cure the problem by way of disapplication. If I can then turn back to interest, and to an extent I'm in the court's hands here, but I'm going to make, if I'm permitted to, make my submissions to explain what our current position on this is. Not least because, to some degree at least, Mr. Johnston's relying on me to deal with interest, and he may be disappointed if I don't. Our position is, as I put it yesterday, more nuanced than the terms of our ground 5 would suggest. The Commissioner's position, with respect, remains rather confusing and in some respects obscure. The starting point must be, I suppose, what the Upper Tribunal said in paragraph 169. So that's Core Bundle 1, tab 4, page 88. In that paragraph, the Upper Tribunal said the conforming interpretation given doesn't address the liability of the appellants to interest. Interest payment is therefore governed by the usual statutory provisions. Whilst interest is strictly outside the scope of our decision, we consider that it may be of assistance to the parties to provide them with our view on how any liability to interest would arise in respect to the exit taxes. The liability to interest as regards the trustees is governed by Section 86 TMA and would run on the outstanding amount from the relevant date. As regards Redevco, interest is governed by Section 87A. This provides that interest runs from the date on which the tax becomes, quote, due and payable under Section 59D, which is normally the day following the expiry of 9 months from the end of the relevant accounting period. We note that this is consistent with the liability to interest which arises when tax is deferred under Section 281. So one has there a recognition that the conforming interpretation that had been given by the Upper Tribunal didn't address the liability of the appellants to interest, that interest payment was therefore governed by the usual statutory provisions, and as expressly recited by the Tribunal, that interest was strictly outside the scope of its decision. But there was also, if one goes back to paragraph 165 on the same page, there was also a specific ruling in paragraph 165 that the conforming interpretation adopted in Panayi FTT and Redevco FTT provided that there would be no liability to interest other than interest on late payments. So we find that this aspect of the FTT's decisions goes beyond what's required to give effect to the EU law rights of the appellants, and in so doing, the FTT made errors of law. We note that there are no statutory appeal rights to the FTT in respect of interest, and therefore the liability of the appellants to interest was not before the FTT. In any event, the CJU has held that the payment of interest doesn't interfere with the freedom of establishment, and therefore adopting a conforming interpretation that addresses interest goes beyond what is permissible. We find that the FTT, in Panayi FTT and Redevco FTT, made an error of law in making provision for interest not to be paid in the conforming interpretations that they adopted. But in fact, we can look at this in due course, the conforming construction adopted by the FTT in our case was entirely silent on the question of interest. So we respectfully submit that so far as Redevco is concerned, Panayi is in a different position. The ruling in paragraph 165 is wrong for the simple reason that the conforming interpretation adopted here didn't say anything about liability to interest. Can I try to put in context what seems to have happened here? In Panayi FTT, so that's Core Bundle 2, tab 24, at page 434.
Sorry, Core Bundle 2.
Tab 24, page 434. In paragraph 166, under the heading The Conforming Interpretation, Judge Mosedale held that a conforming interpretation of section 59B, would include an option to defer payment of the exit tax in 5 equal annual instalments without liability to interest, and then in brackets went on to say interest would of course arise under the normal legislative provision, section 86, to the extent that an instalment was unpaid after its due date. Now in our case, before the FTT, the commissioners relied upon that ruling. That's to say their position was that if, by a process of conforming construction, the payment date in section 59D was read as providing for payment by instalments, then the dates on which such instalments were payable would be the due dates referred to in section 87A, from which interest would then run. Section 87A1, we don't need to go there now, is at Authorities 1, tab 3, page 48. Now, if we go to the supplemental bundle, we can see what the commissioners were saying in our appeal to the FTT. So behind tab 10, Page 104, paragraph 42. The Commissioners relied on the conforming construction in Panayi FTT as referred to with apparent approval by the Upper Tribunal in Banks. And you'll see there what the Upper Tribunal said in the quotation at paragraph 42 from paragraph 237 in Banks. The conforming interpretation that Judge Mosdale chose in that case, as set out at 166, was that the legislation in question should be read as including an option to defer payment of the Section 80 exit tax in 5 annual instalments without liability to interest. And we've seen, I think, 165 and 166 of Panayi FTT. What then happened in our appeal, so that was what was relied upon, it seems, by the Commissioners in their skeleton. I complained is perhaps putting it slightly too high, but I questioned on day 2 of the hearing in the FTT the fact that we hadn't been provided by the Commissioners in writing with the conforming construction of Section 59D, which they were proposing, and very helpfully, over the short adjournment on day 2 of the hearing, the Commissioners produced both a longer version and a shorter version of their suggested conforming construction. And that's recorded in the FTT's decision at paragraph 23, which is in Core Bundle, tab 8, page 138. In fact, if one looks at paragraph 23, perhaps question was putting it a bit mildly. Perhaps I did complain, because it says, HMRC, having been criticised for failing to do so sooner, produced the following alternative conforming interpretations. And you'll see that the short version and the longer version that were produced. And,
sorry, I'm sorry, I'm behind you. Which tab are you in now?
Sorry, Core Bundle 1, tab 8, page 138, my lord.
Yeah.
So that's the wording that was then produced after the short adjournment on day 2, and that's also picked up in the transcript, and not really for that purpose, but to look at what was then said. If I could, I'm sorry to keep moving between bundles. If I could ask my ladies, my lord, you to go to the supplemental bundle behind tab 11.
Page.
It's page 109, forgive me.
Yeah.
One sees from my learned friend Mr. Elliott's submissions at that point in the hearing, the Commissioners were relying on inviting the FTT to follow the position on interest taken in Panayi FTT and previously referred to in their skeleton on the basis of what had been said in Banks. And then internal page 93, line 15, learned friend Mr. Elliott said there are two versions, long and short. Then he says, secondly, it matches mutatis mutandis, the main version held up to Judge Mosdale and Panayi, which she accepted. And then said, thirdly, maybe just to kill off this point, which has been rumbling around, is interest. You don't have to say anything about interest. One, because of the jurisdiction point, but secondly, because if you don't, actually the interest will flow from this anyway, because interest runs from the date of payment in section 59D1. That comes from section 87A, which for your reference, etc., isn't in the bundle. If you said nothing about interest, which is what we invite you to do, interest will run from the date of each instalment. So there'll be no interest on the first 12 months, then there'll be interest on 80% for the next year. And Judge Brooks asked, so it's the same position, as Judge Mosdale said, and counsel said exactly the same as what Judge Mosdale decided in Panayi. And if
Is
one,
that actually right? Are those two things consistent?
well, I think what seems to have happened,
Because the 80%, I'm just thinking about it, but if it's 5 instalments, surely you only have to pay 20% a year if it's over 5 years. And you'd have to pay, if you're just paying interest on late payment, then since you're only paying 20% per annum, you'd only have to pay interest on 20% if you were late. Whereas this is saying there's interest on 80% in the next year. So this seems to be saying two inconsistent things.
it may be that you'll hear from my learned friend in due course on this, but what we take from this is what was being said was you don't need to do anything in relation to interest, because interest only runs from the date when the instalment's actually payable, and that is consistent with what had been said in Panayi. Because if one goes over the page, forgive me, to page 110, you've again got on internal page 40. And it's line 21, right at the bottom right-hand corner. If we're looking at 59D, nothing like that in there. Should there be interest? Well, if you're only amending only section 59D1 and you don't say anything about interest, actually the interest simply flows because interest only runs from the date when the instalment's actually payable. Keep it simple. Don't worry about that. Should there be security? No. Now that last point picks up on the fact that I've made the point that Schedule 3ZB included provisions, as you heard from me yesterday, in relation to interest, but also security and penalties, in relation to my point about scheme and choices and this being a matter for Parliament. And then there's a reference to Judge Mosdale's decision in Panayi at 166 that starts on line 7 at page 41. Now, as we understood the FTT's decision in our appeal, it's to be inferred that the FTT accepted HMRC's submissions. And I say that because if one goes, please, to the core bundle, volume 1, it's tab 8 at page 144. You've got there Judge Brooks referring to what Judge Mosdale had said in Panayi FTT. Forgive me, it's paragraph 41 on page 144.
Sorry, my fault. Thank you very much.
So you've got reference to Gallagher and then a reference to Judge Mosdale's treatment of these issues in relation to interest. And over the page in paragraph 43, there's a further reference to what Judge Mosdale had concluded at paragraph 166. And then he said, having referred to those passages, he said that he, and this, forgive me, page 149, paragraph 62, is paragraph 62. He says, I consider a conforming construction to be appropriate in the present case and have no hesitation in following Panayi. That's to say in relation to the question of whether a conforming construction is appropriate, and that he gratefully adopted Judge Mosdale's reasoning in relation to section 49 which should be 59B, which is equally applicable to section 49D, which should be 59D in the present case. But whilst he may, it seems, have inferred and certainly didn't dispute what was being said to him on behalf of the commissioners in terms of following the approach in Panayi, in fact, the FTT's conforming construction, as one sees from paragraph 62, by contrast with Judge Mosedale's formulation in Panayi FTT, was actually silent on the question of interest, which is perhaps unsurprising because that's actually the approach which Milan and Friend invited him to take. Now, even leaving aside for now the question of jurisdiction, which I'll come back to in a moment, in circumstances where HMRC's case before the FTT was that the conforming interpretation in Panayi was correct without any sort of qualification, from which it would seem it followed that interest accrued from the date of each instalment, it was hardly a point, we would say, which HMRC could seek to cross-appeal to the Upper Tribunal, and nor for that matter was there any intimation that the commissioners had any issue with that outcome or sought to challenge it. There was nothing to the contrary in their response to our grounds of appeal. And their skeleton argument in the Upper Tribunal appeared to maintain the position on interest which they'd taken before the FTT. And if I could just ask the court, please, to look at that. It's at supplemental bundle, tab 15, page 179. Right at the bottom of the page, as a footnote, which states, for completeness, the tribunal is not required to consider any issues relating to interest because such matters are not relevant to the amendments made by the final closure notice. In any event, the solution in relation to interest is straightforward. UK provisions on interest, in particular section 78A, apply according to their terms alongside the conformably interpreted section 59D of the Taxes Management Act. And generally, in their skeleton argument, HMRC sought to uphold the approach taken in Panayi FTT as had been followed in our case by the FTT without any sort of qualification. So we say against that background, it's not surprising that there wasn't any discussion of interest in our grounds of appeal to the Upper Tribunal or our skeleton, save for it being noted in our skeleton. And my ladies, my lord, you'll see this at the previous tab of the supplemental bundle at page 121. Save as one sees from footnote 4 at the bottom of that page. We said, by that construction, HMRC submitted that the date for payment was deferred to the date of each instalment payment, so that interest only began to run from the date of each instalment, and then there are references to the underlying documents. It's noted in the parallel Panayi appeal, HMRC now contend that the FTT in that case erred in producing that outcome. See HMRC's document entitled FTC1, Form Box 8, Reason for Appealing. Clearly that point is not one which it's open to HMRC to take in the present appeal. And there was no challenge to that I'm aware of by the commissioners. If we then step aside for a moment to what happened in the Panayi appeal from the FTT to the Upper Tribunal, still in the supplemental bundle, tab 22, there's HMRC's response to the trustees' notice of appeal. And if one looks at paragraph 12 on towards the bottom of page 259, that says that two further ancillary matters relating to the conforming interpretation adopted by the FTT arise concerning A, interest, and B, security. As neither has any effect on the disposal of the appeal, they're addressed at the end of this response in paragraphs 37 to 47 below. if one then goes forward in the same document to paragraph 37 on page 269, there's the reference there to what the FTT had held in Panayi FTT. That's under its conforming interpretation, interest would not be payable from the date specified in sections 59b4 and 86.2b, namely the 31st of January 2006, but instead would only be payable from the later date that an annual instalment became due. 38, this finding doesn't affect the outcome of the appeal. The FTT correctly concluded that the appeals against the amendments to the appellant's returns affected by the closure notices fell to be dismissed. But then in 39, it said that the FTT went too far in holding that interest would only be payable from the date that an annual instalment became due. And in 39.2, that providing to interest, for interest to run from the ordinary date in section 59b4 doesn't involve any alteration at all to the legislative scheme. Alternatively, doing so doesn't involve any alteration at all to the legislative scheme or is a more straightforward alteration. But if one then looks at what was said in paragraph 40, so this is over the page on 270, it said that the FTT should have held, although this does not affect the disposal of the appeal, that it was unnecessary to amend the date from which interest would be payable. In 41, that the FTT did not have jurisdiction to make any binding declaration as to the date from which interest would be chargeable. In 45, which is over on page 271, that there's no statutory right of appeal against interest charged under section 86. And in the same paragraph, that while this had no effect on the disposal of the appeal, the FTT had no jurisdiction to make a binding determination. And there's also, for the sake of completeness, something said in paragraph 42, back on page 270, about there having been a protective appeal out of an abundance of caution, but the issue has no bearing on the amendments made by the closure notices. So that was that document. But if one then goes, please, forward to the next tab, tab 23, so that this is the Commissioner's position by the time the hearing came before the Upper Tribunal as reflected in their skeleton. If one then looks, please, at paragraph 46 on page 288, what was said there was that there was no need for the FTT to address the question of interest separately. Any question as to interest would be resolved simply by applying the principle that once the conforming interpretation was made to a given statutory provision, the other UK statutory provisions apply alongside. And then in 46.3, one sees there, as FTT 158 held, the conforming interpretation is to read words into section 59b to permit payment by instalments, applying section 86 alongside section 59b conformally construed. If an instalment payment was not made upon the required date, interest would run from the date upon which that instalment payment fell due. And then, if one can go back, please, in the same supplementary bundle to tab 16, one sees that in the actual hearing before the Upper Tribunal, so this is page 191, so this is day 3, page 12, so bottom right-hand corner, lines 3 and following. Mr. Bremner, King's Counsel, said on interest, the principle that the other provisions of UK law apply alongside section 59b conformly construed, that gives the answer. And then over the page, at 192, internal page 13, starting at line 11, Mr. Bremner is recorded as saying, now what we have in this case is a conforming interpretation to read words into section 59B to permit payment by instalments. What that's going to do is to make the date upon which the tax becomes due and payable a later date. So the due and payable date will be the date of each of the specified instalments. So if you apply section 86 alongside section 59B, conformally construed, if an instalment payment wasn't made on the required date, then interest would run from the date upon which that instalment payment fell due. In my submission, one sees that the position being taken there on these appeals was entirely consistent, really, with what had been submitted by the commissioners in Panayi FTT, and perhaps inferentially followed by Judge Brooks in our appeal to the FTT. So far as submissions made specifically in our appeal to the Upper Tribunal are concerned, if I could ask the court please to go forward to page 197 in the same tab. All that's said there, and this in circumstances where there'd been no dispute previously raised in our appeal in relation to what had been said or indeed not said on interest in our case. My letter from Mr. Elliott says, internal page 118, bottom left, starting at line 10, interest will follow from your decision as to what is the appropriate conforming construction. We've seen 87A, the interest generally runs from the date due and payable, and considering the discussion this morning, there are slightly different ways in which you might want to apply it. Probably the analysis that's closest to the CJU's jurisprudence is that interest does indeed run from the original section 59 date, i.e. 9 months after the end of the accounting period. But if you decided to go with what Judge Brooks' analysis was, because he did in fairness change the due and payable date, then section 87A would simply flow from the new due and payable dates of the 5 instalments. It depends which conforming construction you consider is closest to the grain of the existing legislation. And my learner from Mr. Bremner has already mentioned sections 280 and 281. So that's the most that it can be said was said in these appeals with a view to getting the Upper Tribunal to engage at all in relation to interest, and all of this in circumstances where leading counsel in the Panayi appeals, whose submissions generally were adopted by Malone from Australia, was saying, no, you just do it. It all sits alongside. You don't have to say anything. It will run from the date of the instalments. So far as the Upper Tribunal's position is concerned, I've taken you, I hope, to the relevant paragraphs. They say that it's strictly outside the scope of their decision, but then they say, with a view to assisting the parties, they're going to offer a review. And they do that in circumstances where there is obviously a question as to the Upper Tribunal's jurisdiction, both in respect of interest generally, and in the circumstances of this case, given the history of the appeals, to engage on the question of interest at all. And there's also then the question of whether, given the way in which the matter was argued before the Upper Tribunal, in relation both to the Panayi appeal and our appeal, it was appropriate for the Upper Tribunal to take it upon itself to deal with a matter which had not been the subject of anything like full argument and indeed was not understood to be in dispute. Now, it may be that some of these matters I had best leave to deal with by way of reply, depending on how the Commissioner's position on this is developed. Their position, as appears from their skeleton, seems to be that the Upper Tribunal, as put in quite stark terms, was entitled to raise arguments that were not strictly before it, and that we'll have a full opportunity to address the issue before this court, should the court wish to hear submissions on the issue, and that will remedy any procedural unfairness, and therefore there be no prejudice overall. Just on those points, and again, perhaps it's best if we wait to see how they're developed on behalf of the commissioners, but we wouldn't accept that the case law on a tribunal being entitled to raise arguments that weren't strictly before it would permit it to decide, or indeed even in the circumstances of this case, where the consequences of its remarks on a matter which hadn't been argued, certainly hadn't been argued fully, weren't understood to be in dispute, and which it said were outside the scope of its jurisdictions, that its remarks made in a judgment without being trailed.
Mr. Marvin, is this just a way of saying that the observations made by the Upper Tribunal about interest are obiter and not binding on anyone?
Well, I'm not, my lady, I'm not sure. I've thought about this. I'm not sure whether actually the strict characterising is obiter as opposed to simply something with not even purporting to have legally binding effect. But of course, it seems from revenue skeleton, for example, that they are nonetheless somehow seeking to, if I can put it this way, bank what had been said by the Upper Tribunal and say that this court does somehow have jurisdiction to give some sort of ruling on the matter.
Well,
although
you're right, it's best to find out what HMRC is saying. I mean, my provisional view, and the background that you very helpfully explained, is that these observations aren't binding on anyone.
And it may be that, if depending of course on what the commissioners say, it may be that all I need to do is to invite this court by way of confirmation to endorse the position that these are not of any legally binding effect, but I'm not sure quite what the commissioner's view is. And I'm not sure in the circumstances whether the court is going to be interested in dealing with a point insofar as it is identified as a point on interest that wasn't within the first tier tribunal's jurisdiction, never came within the upper tribunal's jurisdiction, hasn't been the subject of what is said to be a definitive ruling. But can I just say, and perhaps keeping my powder dry on the substantive issue, first we would say that the upper tribunal was wrong to say that the FTT's conclusion in Panayi FTT involved going beyond what was required by EU law, simply because the authorities established that interest can lawfully be charged in an exit tax context, that imposing liability from the day following the expiry of 9 months from the end of the relevant accounting period, which is what the view offered in 169 by the Upper Tribunal was, isn't what EU law requires. There's no requirement for the payment of interest or the requirement of a bank guarantee. They're not necessary elements for compliance.
Isn't the issue rather whether EU permits it?
Well,
Anyway, it doesn't.
I think my point on that is, and we don't need to get into this, but the approach that seems to have been taken by the Upper Tribunal, we say, is wrong, but perhaps I should wait to hear how the commissioners deal with it. That section 281, which is invoked at the very end of the decision, is neither here nor there. But there is actually one final point which I can make, which goes to our other grounds, which is that it might be said that the very fact that the FTT, at least so far as it did so expressly in the Panayi appeal, where Judge Mosedale's conforming interpretation did explicitly address interest, on the one hand, and the Upper Tribunal in its remarks have reached different conclusions in relation to interest, may be thought significant in itself, suggesting as it does that the tribunals have perhaps stepped into the legislative arena and made policy choices, and different policy choices, serving to highlight the range of choices available, which are properly matters for Parliament rather than for the courts. But perhaps, subject of course to the court's view, I should confine my submissions on interest to that at this stage.
I think that's best.
In which case, unless I can give any further assistance, those are my submissions.
Thank you very much indeed.
Well, ladies, my lord, I'm conscious of the time, we've told Mr. Fell he'll be on by past, so I'm going to very briefly address you in relation to a question raised yesterday in relation to how deferral until realisation has worked in practical terms on the authorities. As you recall, that arose out of my submission under ground 1, that deferral until realisation is an option under EU law that the Upper Tribunal could have chosen, and also in the strict alternative under ground 3, that the better conforming interpretation is either that the value of the asset is determined and that the assessment to tax happens at the point of realisation, or that the value is quantified at the point of departure, but the date of assessment to tax and payment is the date of realisation. So those were the two alternative ways I was putting my ground 3. I don't propose to go over that, of course, again, save, of course, to clarify, in fairness to the revenue, that there is a possible third option, which is that the valuation and assessment happen at the point of exit, and it's only payment that is deferred. And in fairness, that is, as you may have seen, how Schedule 3ZB does operate, where there is deferral. And it was put to me by my lord yesterday that that may be what the revenue was suggesting in 2018. It may be that that is what the revenue was suggesting in 2018. We'll hear what they say. And of course, as your lordship pointed out, that would be less advantageous to my client. So that's the context. I was asked for some examples of how this has been worked out in practice in the case law. The short answer is that there is not, so far as I know, been a case referred to the Court of Justice that has tested the mechanics and the legality of a mechanism of deferral until realisation. And when one looks to the authorities, that's perhaps unsurprising because of the way that the case law has evolved. The very earliest cases of this kind, the question that's being asked is whether a scheme for immediate payment rather than deferral until realisation was lawful. So that's the question the court is grappling with, because the difference in treatment is that one must pay capital gains tax, whatever the relevant taxation would be now, rather than at the point of realisation. But there was no specific scheme of that kind before the court. The schemes before the court were payment immediately. And if I can put it this way, the hypothetical alternative that the court never had to grapple with the detailed mechanics of was deferral until realisation. Just to give you a small number of authorities, references to some authorities to assist you on that, I think I'll read them all to you rather than take you to them given the time. The first is N and the Inspecteur at tab 85. And the key references for you there are paragraph 35, where this point about a disadvantage arising because you have to pay before the sums are realised is articulated, and that's on page 2759 of the authorities bundle. Page 2760 is also significant, paragraphs 49 and 50. The court there saying you don't have to delay valuation, so assessment, until the point of realisation, but you could. So what they're saying is there are different ways in which this could be done, and then the conclusion paragraphs in that judgment at 55, and what follows from that, if you have an opportunity to read it, is that early payment before realisation is the court's concern. It's in fact the question referred because it is the difference in treatment, if I can put it that way. Ordinarily, I would only have to pay capital gains tax at the point at which it's realised. If I have to pay at the point of exit, then I have to pay before then. Is that unlawful? Answer, yes, from the court in N. National Grid Indus, you saw yesterday, that's at tab 88. The question there is again about an obligation to pay before the assets are actually realised, and maybe that's worth turning up. So that's at tab 85.
88?
88, I'm very grateful. N was 85. It's at tab 88, and page 2905, page 37. Paragraph 36. So 2905, paragraph 37. So in the case of the main proceedings, it is clear that a company incorporated under Netherlands law wishing to transfer its place of effective management outside Netherlands territory in the exercise of its right guaranteed by Article 49 is placed at a disadvantage in terms of cash flow. So that's the other way the court puts it, compared to a similar company retaining its place of effective management in the Netherlands in accordance with the national legislation at issue in the main proceedings. The transfer of the place of effective management of the Netherlands company to another member state entails the immediate taxation of the unrealised capital gains to the assets transferred, whereas such gains are not taxed when such a company transfers its place of management within the Netherlands. So the point that they're drawing out there is this difference between the point at which tax is owing by reference to realisation. And then if we go down to paragraph 40, the tax at issue in the main proceedings is not charged on realised capital gains. The exchange rate gain that was taxed in the context of those proceedings relates to an unrealised capital gain which did not produce any income for National Grid Indus. Such an unrealised capital gain would not have been taxed if National Grid Indus had transferred its place of effective management within Netherlands territory. So there you have the court, the reference point, or the question, if I can put it that way, is by reference to not the point of realisation. There is not before the court the question. We have a mechanism now for deferral until realisation. Does that mechanism comply? Paragraph 64, I think, is useful, just very briefly, over on 2910. It follows from the foregoing that Article 49 does not preclude legislation of a member state under which the amount of tax on unrealised capital gains relating to a company's assets is fixed definitively without taking account of decreases or increases in value which may occur subsequently at the time when the company, because of the transfer of its place of effective management to another member state, ceases to obtain profits taxable in the former member state. It makes no difference that the capital gains that are taxed relate to exchange rate gains that cannot be reflected. And then over the page, 68, on this point, it must be stated that recovery of the tax debt at the time of the actual realisation in the host member state, so that's the second member state, if I can put it that way, of the asset, in respect of which the capital gain was established by the authorities of the member state of origin, member state 1, on the occasion of the transfer of the company's place of effective management to the host member state, may avoid the cash flow problems which could be produced by the immediate recovery of the tax due on unrealised capital gain. So this is the court saying that that mechanism would be a way of addressing what I identified to you earlier as the challenge or the difficulty. And then over the page, briefly at paragraph 73 on 2912, I'll let you read that. It's a slightly longer paragraph rather than reading it to you, given the time.
Thank you.
So this is another iteration of the point I was making to you yesterday about choice, which is that at the point of exit, a company can choose, do I have taxation at a later point? I need to trace the assets through. I need to keep track of them, if I can put it that way. Or do I pay at this stage? And that is a choice that must be given to the taxpayer. So what this really is about, in my respectful submission, is the finding that deferral until realisation is an obvious means by which to remedy the disadvantage that's suffered by companies that depart. And that particular process could be done in more than one way. You could calculate value at the point of exit, you could calculate at the point of realisation. I promise, Mr. Fell, I'll be one more minute. I won't take you to the third authority, that's DMC, you've seen it. The question for the court in DMC, if I can crystallise it this way, is whether or not in light of those authorities, it is lawful to defer payment in 5 stages. The court has established that it's lawful to defer until realisation, and that's the nub of DMC, if I can put it that way. And you find the answer to that question in paragraph 53, where the court says it is not unlawful to make provision for a chargeable event other than actual realisation. And so that's where they say, actually, not only deferral to realisation, but also deferral for 5 years is the kind of thing that would be lawful. So obviously what we take from this, no particular scheme of deferral to realisation has been referred. and the precise mechanics of how this is to be done, if it were to be done, haven't been prescribed or even really grappled with by the Court of Justice. I'm very grateful for your indulgence. My ladies, my lord, I hope that was helpful by reference to answering the question from yesterday.
Thank you very much.
My ladies, my lord. I propose, first of all, just briefly to outline the structure of the submissions which we're going to deliver. Mr. Elliott and I should say I'm a relative newcomer to this case, but Mr. Elliott and I are going to divide up our submissions, so we're going to share the submissions. And we've had, obviously also had a great deal of assistance from Ms. Cranmore behind us. So the structure in which we're going to address our submissions involves 4 blocks of submissions. The first block, which I will cover, is the EU law requirements relating to exit charges. So in the course of that block, I will address 3 particular questions by taking the court through the chronological sequence of development of the cases and then looking at the UK case law. The first question is, what does EU law require relevantly in relation to exit charges? The second question is, in what respect does UK law, absent a conforming interpretation or disapplication, not comply with those requirements? And then the third question is, what would UK law need to have done to comply with those requirements? So I will address those 3 questions in my block 1, which will focus on EU law. Then in block 2, Mr. Elliott will address directly the question of a conforming interpretation so as to comply with EU law. And we do say that it is important to have done the EU law stage first. So analytically, it's really important to be clear about what EU law requires before you start getting into conforming interpretation. And in the course of his block 2 submissions on conforming interpretation, Mr. Elliott will first of all give submissions on the principles governing conforming construction, including some illustrations of how this court in particular has historically done it. Then he will advance HMRC's positive case for why the conforming construction which was adopted by the Upper Tribunal should be accepted. And the effect of that would be that you can read in a right to defer payment of the exit charge tax in the form that was found by the Upper Tribunal. Then Mr. Elliott will on a slightly more thematic basis, address some key objections in relation to conforming interpretation raised by the appellants, relating in particular to the arguments around legal certainty, contra legem, judicial legislation, impermissible choices, and he will also address the slightly vexed question of interest. Then in block 3, which Mr. Elliott and I will share, we will each directly address the specific grounds which had been advanced in respect of each of the 2 appeals. So Mr. Elliott will respond directly to the grounds advanced in Redevco, drawing on obviously on his earlier submissions, and I will respond directly to the grounds advanced in Panayi. And then the final block, which is block 4, will be dealt with by me, and I will deal with what I might refer to very shortly as HMRC's Respondent's Notice point. It's not necessary for the court to go through it right now, but there's Respondent's Notice in Core Bundle, tab 12, page 219, and the effect of the Respondent's Notice point is that if a conforming interpretation is not possible for whatever reason, then we get into disapplication, and HMRC's contention is that disapplication gets you to essentially the same outcome which you arrive at on a conforming interpretation. We note that Judge Mosedale in the First Tier Tribunal did deal with this argument and endorsed HMRC's contention that essentially you end up with the same outcome in the appeal. We don't need to go to it, but that's at paragraph 174 of the FTT's decision, which is Core Bundle, tab 24, page 435. And just because we perhaps haven't heard a great deal about disapplication in particular, I might just very quickly canvass the argument. The fundamental point is that the court can't escape the need to identify and vindicate the EU law right to defer payment, which is, I think, a way in which, I'm not taking it out of context, but a way in which Lord Justice Miles yesterday suggested one could characterise the right in question. This application itself is a proportionate process in which a statute is disapplied to the extent necessary to ensure that national law applies without prejudice to EU law rights. So we say that the resolution in this case, which is EU law compliant, involves respecting an EU law required right to defer payment as an additional option over and above immediate payment. And we say that this application, applied in relation to the payment obligations in relation to the tax in question, achieves that same outcome. And I'll deal with that in detail when I get to block 4, but I just thought it might be helpful to just explain at the outset where we're coming from in relation to this application. So that takes me directly into my block 1 submissions. What I'm hoping, perhaps unrealistically, is that by the time I finish block 1, the court will feel that it has from me a clear sense of what the important EU law principles are about exit taxes and which authorities establish those principles. And secondly, an explanation of HMRC's legal position in relation to the contention that EU law on exit taxes requires that the taxpayer have a choice as to immediate payment or deferment, which goes beyond a conventional legal right to pay immediately or defer. And so that's an argument which Panayi in particular have advanced. So it's also been adopted by Redevco. But that argument, it seems to us, is a contention which depends on the construction and interpretation of the EU law jurisprudence on exit taxes. And so I'm going to address you on it as we go through the cases. But in essence, our contention is that what the cases suggest is required is a legal right to defer payment as an alternative option to immediate payment, as distinct from something more, such as an actual fully informed choice at the time of exit, which is, I think, what is being argued is required by Panayi. They say there's something very distinctive about the words like choice and option which are used in some of the cases, which suggests that more is required than merely a legal right. So the first question is, what does EU law require in relation to exit charges? And I'll make a conceptual distinction at this stage between 3 different stages of the inquiry, which one finds time and time again in the EU law jurisprudence on this topic. And the first stage is there a restriction on an EU freedom, a treaty freedom? And that is answered in essence by reference to the question, does the measure hinder the exercise of an EU treaty freedom or make its exercise less attractive? So is there a restriction? That's stage 1. Stage 2 is, insofar as there is a restriction, is it justified? And that's addressed by considering whether the measure, that is the national measure, pursues a legitimate objective in the public interest. And then the third question, to the extent that it's found that there is a restriction which is justified, is it proportionate? And that question is answered by a consideration of whether the measure goes beyond what is necessary to obtain the legitimate objective which justifies it. So if we now start going through the cases, and we'll start with the case of N, which is in the authorities bundle, tab 85, page 2725. So this is an early case. It's the best example of the initial articulation of the principles, particularly around the question of a restriction. Mr. N, and we get this all from the head note, but I'll just quickly summarise what the case was about for the court's benefit. Mr. N emigrated from the Netherlands to the UK in 1997. Under Netherlands law, there was a deemed disposal of shares he held in 3 Netherlands companies when he migrated, which triggered a liability to pay tax. And slightly confusingly, under the Netherlands system, it's actually income tax that was triggered, but that doesn't matter. It's still effectively a gain on the increase in the market value of the shares. And it was measured at emigration. And he was granted a deferral of payment, but he could only have a deferral of payment if he provided security taking the form of collateral, and the collateral was some of the shares which he owned. So quite a demanding form of security. And he challenged the law as contrary to freedom of movement. And if we take the stages of the court's analysis in turn, by going first of all to paragraphs 35 and 36 of the judgment, that's page 2758. So, first question, is there a restriction? And you see the court answering that question in paragraphs 35 and 36. In essence, yes, emigration makes emigration disadvantageous in comparison with a person who maintains residence in the Netherlands. And there's a reference in particular to the difficulties created by the guarantees, at paragraph 36. So the next stage in the analysis is whether or not the measure is justified. So if we go to paragraph 40 over the page, we see the court referring to its well-established principle that a restriction may be allowed if it's justified. That is, may nevertheless be allowed, this is the middle of paragraph 40, if they pursue a legitimate objective and don't go beyond what's necessary to attain it. And so then the question is, well, can this measure be justified? And in order to work out whether a measure is justified, you have to identify what its objective is. And at the bottom half of paragraph 41, the court observes that the national provisions at issue in the main proceedings are designed, in particular, to allocate between member states on the basis of the territoriality principle. So you tax the residents of your own state, the power to tax increases of value in company holdings. That's the objective. And at paragraph 42, the court finds that preserving that allocation of the power to tax is a legitimate objective. It refers to its earlier decision in Marks and Spencer. It then goes on in paragraphs 43 through to 47 to make some observations about how there isn't a community level unified position on how you should allocate taxing rights between different countries. It's not harmonised, that's paragraph 44. And in those circumstances, it's suggested that it's not unreasonable for member states to find inspiration from international practice, and in particular model conventions. And the court then refers at paragraph 46 to the extremely well-known OECD Model Tax Convention. And they refer back to the Advocate General's opinion. This was Advocate General Cocotte, who we'll see is a character who crops up quite repeatedly in this line of cases. But as the Advocate General had observed, in accordance with the principle of fiscal territoriality connected with a temporal component, namely residence within the territory during the period in which the taxable profit arises, the national provisions in question provide for the charging of tax on increases in value recorded in the Netherlands, the amount of which has been determined at the time the taxpayer concerned emigrated. So, taxing an increase in the value of an asset within your territory at the point when you lose your right to tax, you lose your sort of practical ability to tax because the resident is moving or the asset is moving, is justified under EU law, subject to proportionality. And the court's inspiration, which seems to have originated in Advocate General Cocotte's opinion, was Article 13, Paragraph 5 of the OECD Convention, which provides that gains from alienation of property should be taxable only in the contracting state the alienator is resident in. Now, as for proportionality, the court addresses that in paragraphs 51 through to 54. The court observes that the obligation to provide guarantees, whilst it helps with collection, is more, the court thinks, than is necessary or proportionate to ensure effective collection. It refers to various reasons to do with mutual assistance directives. And then it also refers to, at paragraph 54, to the ability to deduct losses which occurred subsequently, which is a position on which the court subsequently reverses its jurisprudence. I would like to also add at this point that in relation to the losses question, that's not an issue in this case because the CJU in Panayi specifically ruled that there wasn't any problem with Panayi not being able to deduct subsequent losses, that being a matter for the subsequent host state. And that's, for your note, is Panayi paragraph 58, tab 95, page 3086. So this is the sort of the court's first really substantive exploration of the issues, and you can see that some of the principles aren't fully developed. There's a very interesting discussion in Advocate General Cocotte's opinion. So if we go to, so first of all, just by way of background, I should explain that the Netherlands, realising that perhaps it had a problem, an EU law problem with the guarantee, with the security that it was requiring, subsequently released the security. So it released the security after the event, and the national court asked, does that solve the problem if the security has been released? And so if we go to page 2734 of the authorities bundle, we've got the question at paragraph 4. We're in the Advocate General's opinion here, and the AG is setting out the fourth question, which is that if question 3 is answered in the affirmative because of the fact that security has to be provided, i.e. if there's an EU law problem because security has to be provided to enable deferment of the tax. So it's the idea that you've got this gateway that you've got to get through an absolute requirement for security. Can the existing obstacle be removed with retroactive effect through the release of the security provided? And then the court goes on to ask, well, and would it make a difference if you could get compensation as a taxpayer? And it's a little indirect, but I think it is helpful to look at what the Advocate General says about these questions. So if we go on to paragraphs 124 through to 125, so that's page 2749.
And this is still the Advocate General.
This is still the Advocate General.
Yeah.
So she's gone on to the 4th question, paragraph 124. The National Court asks in substance what a member state must do to remove any consequences of the fact that in breach of community law, the tax used to be deferred only on provision of security. And I mean, the answer is I think, illuminating. So paragraph 125, the Advocate General says, we recall that the tax assessment linked to emigration still exists as such, and as held above is lawful. The fact the tax assessment was originally linked with an obligation to provide security does not affect its lawfulness. On the contrary, one must clearly distinguish between the tax assessment and the fact that the tax liability was deferred only on provision of security. So already you've got a distinction being made between the tax charge and indeed, on the language of this opinion, the assessment associated with the tax charge and collection of that liability. And then she goes on to say at paragraph 127, thus all that remains is for the court to decide whether the release of the security, as the court puts it, removes the obstacle with retroactive effect. In substance, the question amounts to whether the release of the security is itself sufficient, or whether community law requires in addition that all other disadvantages flowing from the provision of the security are eliminated. And then she goes on at paragraph 128 to talk about the possibility that there might be a need for financial compensation. And so she talks about how perhaps there isn't much evidence in that particular case, but providing security might involve costs. And last sentence of paragraph 128, releasing the security is not enough to compensate for such financial losses. Now, I've got 2 observations about this reason. It's a little bit indirect, but the first point is that she's very clear that the breach of EU law doesn't invalidate the tax charge or the assessment. And the second is that if the emerging principle was that the taxpayer had to have a choice, a fully informed EU law compliant choice, which wasn't interfered with, and if they didn't have that, then there's not at that point really any way of solving the problem, as it were, then you might expect the Advocate General to have said that, rather than to have just focused on the question of whether or not compensation might be needed. The answer which is given to the 4th question, I would suggest, it's a little indirect, but it doesn't sit comfortably with, it's totally inconsistent with the idea that the tax charge or assessment is in any way invalidated or frustrated. And it doesn't sit comfortably with the idea that the emerging principle is that you have to be given a choice, which is something over and above your legal rights. So that's N. The next case in order which I want to look at is National Grid Indus. And I'm going to, well, I'm in your hands, my lady, as to whether I keep going or stop and we come back and start with National Grid Indus when we've all had lunch?
I think it would be better, given the time, that we turn to National Grid Indus at 2 o'clock. Thank you very much.
All right,